Good morning. Um, so when I was preparing for this webinar, um, I was thinking of an alternate subtitle, and with due credit to Broadway's Stephen Sondheim, it could be a funny thing happened on the way to project completion. And I thought that was an apt description because of the dynamics in any capital construction project and the amount or the different players involved, ranging from obviously the owner, the school district, the architect, engineers, construction manager, contractor, subcontractor, suppliers, sureties, and then the host of issues that can come up in any particular project, ranging from budget overages, errors and omissions, contractor performance, construction defects, bidding issues, bid challenges, supply chain issues, material escalation costs, labor shortages, terminations, defaults. Rarely does a project go as planned. So representing owners in connection with projects for the last couple decades, I've tried to develop a certain, tips, and they're not exclusive, but here today we're going to talk about 10 tips that hopefully allow you to avoid setbacks in your project and minimally mitigate those setbacks. So let's move to tip number one. And essentially at the developing and defining the goals and objectives and expectations for the capital improvement project. Obviously, it's going to be subject to voter approval. So a suggestion is to communicate the program early and often to the project stakeholders, to get buy-in and interest and enthusiasm for the project. With the presentations that I know a lot of districts do, and the information, the mailers, that type of thing, it kind of demonstrating what the project is or what's expected to be, the timelines, the cost, and the benefits to to your constituents, the students, the staff, and the general public. Stakeholders will obviously expect, what's been promised in the project information documents to be, delivered by the owner. So, having a realistic definition of your project and what the expectations and what the deliverables are makes sense. And also then initial well-defined project will hopefully, keep you on track and avoid scope creep that can, result in project delays and budget overages. And, early on in the project, if there's scope creep that in an earlier phase, and then, it costs reduces potential construction in a later phase if the costs are increased due to additional scope or changes. So tip 2 would be to engage a well-qualified design professional early on in the process, your architect. And the RFP process obviously is well suited to identify qualified professionals, and also gives you the benefit of determining, what might be market rate for design fees. Different architects charge different fees, and I think the RFP process allows you to kind of get more information on the fees that you can expect, and to negotiate the fees. Once you have some, a potential candidate, you can always negotiate the fees, and they can sharpen their pencil on their fees. Professional service is not subject to competitive bidding. You just want to do it consistent with the district's procurement policies. The RFP is really tailored, or can be tailored for this process, with whether you want pre-referendum, post-referendum, or both services, the schedule you want, and how you want the compensation to go. And what I suggest often with an RFP process is to include a proposed agreement. We use the AIA suite of documents. The B series is the architect agreements. And when you have a construction manager, it's a B132. And when you don't have a construction manager, it's a B101. But modified agreements that are attached to the RFP kind of set expectations from the design professionals of what the district wants to see from its architect, what it understands the architect's obligations are and requirements for the project are. And also you can, the RFP allows the design professionals to identify now, if you have any issues with those provisions, so, they can be addressed as part of the procurement process. It doesn't always happen where, obviously the architects may look to revise provisions once they've been awarded the contract and before it's been signed. But it does seem to cut down on the negotiations of that design agreement. Tip 3 is, back to the design agreement. Our recommendation is consult with your legal counsel for drafting the owner architect agreement, utilizing the terms that are negotiated through the RFP process. A lot of the times the architects will send over a form agreement, which is modified, in most cases, in the interest of the architect. And I'll tell you, with regard to the AIA contract base form, it's more architect friendly than it is owner friendly. So when we're drafting or responding to an architect's draft of a contract, we modify it to meet to protect the interests of the district and meet the expectations of the district. And to provision to their 20-page agreement. So there's a host of provisions, but the ones that that we focus on are the scope of the work. What are the services you're engaging the design professional to perform? The schedule for those services. What are the expectations of when the design's going to get to SED, when the various phases of design are going to be complete, when it's going to go out to bid, when are the contracts going to be awarded, and then the construction. Is it going to be phased over a number of construction seasons? So those types of things you would put in your agreement with your architect, and the length of the services that the architect's obligated to perform, because once it's past that date, your architect's going to be looking for additional services compensation. So you want to really tailor your agreement, with a realistic schedule, and so you're not so you're buying up front those services and not having to pay additional services. Another provision is insurance. Obviously, you want the insurance to protect the district, and particularly the professional liability coverage. Enough coverage that in the event that something goes wrong and you're looking to your architect for an errors or omissions, and because architects are not highly capitalized firms, they're professional services firms, so the recovery is generally going to be what their insurance provides. So you want to make sure that you have the adequate insurance to protect the interests of the district in the event that there's a claim against the design professional. The standard of care is really what the expectations are of the architect or the design professional, and there's a base AIA standard of care, acting in accordance with a similarly situated architect in a similar location. We tend to add to that to require that they comply with an applicable law, including the ADA, in conjunction with their performance. Another thing is the ownership of the drawings and specifications. That's Article 7 of the agreement, which, who owns the drawings? What happens if you are at odds with your architect and you want to terminate the architect? Does the district own the drawings, or does the district have a permanent license to use those drawings and deliver them to another similarly situated architect to complete the project? So that's an important thing, and it's something you get a lot of pushback with or you may get pushback with the architect on who owns the drawings and the right to use those drawings. So it's something you want to deal with upfront. Compensation is obviously a huge issue. Is it going to be a stipulated sum? If it is it based on your pre-referendum or your referendum construction budget, or is it the project budget? Is it a percentage of the construction costs that are going to be tallied at the end, trued up at the end of the project? And what is the construction cost? There's a provision in the agreement says defines what the construction costs are. And, sometimes, people try to include, is the CM incidental costs are, and we try to limit it to, hard construction dollars and what the contractors have been paid to construct the project or do the renovations. Additional services, that's a provision, the architect's going to be looking for additional services for certain, for doing change orders, for doing, perhaps drafting, or creating, budget, alternates, they may want to be paid for doing alternates. So, those are provisions to negotiate and try to limit the additional services and include as much as possible in the basic services, so you're not paying more than what you contracted for the architect. Obviously, there's going to be things where additional services come up, where there's unforeseen conditions. You hit there's asbestos tile behind something that nobody knew about, and they have to design the abatement. So you're going to have to pay in that instance. Reimbursables, defining what is reimbursable, and then what is there a percentage markup? We try to limit the markup to no markup at cost, but you get a lot of pushback from design professionals and CMs on should there be a markup 5%, 10%, 20%. So that's a negotiation. Dispute resolution, we typically put in strike any arbitration clause and perhaps sometimes have a mediation as an owner option before litigation. And then limitation on liability. There's two aspects of that. Sometimes the architect will propose a limitation on its liability to its fee. We would uniformly strike that provision. And then there's a waiver of consequential damages. It's in the base agreement. Our recommendation is to delete it, because in a construction project, the entity that's going to be consequentially damaged by poor performance is the owner. You can't use your facility. You have to rent, temporary bathrooms because something's not done. The bathrooms aren't done in time because there was a design error. And an architect really isn't going to be consequentially damaged. It has the owner's obligation as a contract is to pay for services. So they have a contract claim. They're not going to become consequentially damaged by the owner's breach in that case. Tip 4 is to establish a clear communication protocol with your design professional and your construction manager. You have an established point of contact for the district. Have an understanding of how decisions are communicated to the consultants. Recognizing that in some instances the Board of Education needs to weigh in and to approve certain changes to the project or changes to their agreement. Recommend, and I'm sure you all do, is establish meetings with your principals and staff to, as to expectations for what's happening in their building and the schedule, when they're going to be, how the building's going to be impacted by construction. And then just to document and keep a record of the district's communications with the team members. How are substitutions coming across? How are change orders being communicated, or changes, or requests for change orders, all that type of stuff you want to have a record of. So in the event that an issue comes up, that there's a clear record of what transpired. Number 5 is to use your legal counsel to review and as appropriate revise the contract for construction, essentially to protect the interests of the school district. So you're again, with regard to the AIA contracts, you're going to have an A101 with an A201 general conditions for a non-CM project, and then an A132 with an A232 general conditions for a construction manager project. And those work in conjunction. So you have the contract, which is a shorter thing with a much larger general conditions, which really provide the responsibilities and obligations of the parties. And together they outline the expectations of what's going to occur. and they're legally binding. And it's these provisions of the contract that you're going to rely on when claims or disputes arise during the project. So it's important to really modify those and include those in the bidding documents. So the contractors who bid on the project are bound by, once the contract's awarded to them, they're bound to enter into the contract that was in the bidding documents and are bound by those general conditions. And the general conditions are an extensive document. As modified, it can be up to 75, 80 pages of single-spaced, provision after provision relative to numerous issues. And some keeper and the base AIA A232 is probably 40 pages. So the ones we with the revisions we recommend to our clients, they're significant and they're designed to level the playing field and protect the interests of the owner. And those provisions include insurance, the levels of insurance for what you need for the project, the commercial general liability. They're also bonding. And as I'm sure a lot of you know who are nicer members, there's been certain changes or updates to the nicer requirements for contractors and for construction projects. So those have been need to be included in it's Article 11 of the general conditions, but those need to be included. There's also provisions of an indemnification in the event that there's the owner gets sued by third parties due to an action of the contractor or its subcontractor. The contractor has to defend and indemnify the owner in that litigation. And so those are important provisions to make sure they're in there and they adequately protect the owner. Change orders. Change orders are a big thing, or can be a big thing on construction projects. And the general conditions can outline that process of what's entitled to a change order, how it's processed, and the payment for change orders. There's also provisions in the construction contract for the schedule. Obviously, the schedule is of immense importance to both the owner and the contractor, because the longer it takes, the more money it costs. And delays, we typically put in a no damage for delay provision, which the contractor's remedy in the event of a delay is additional time, not additional monies. The consideration of liquidated damages. There's different philosophies on including liquidated damages. Some owners believe that having liquidated damages may at the outset put the parties on an adversarial footing in that the contractors needs to price in to its bid the amount of potential liquidated damages and then be on top of from day one any type of schedule slippage that they think they're entitled to additional time. So that may in some owners' views counsel against having liquidated damages and then default to actual damages. So liquidated damages, for example, could be $1,000 a day for every day past the agreed upon substantial completion date. And that's the owner's sole remedy in the event of a delay. There's no other remedy is generally no other remedies available. That's a delay remedy. Without liquidated damages, it will be actual damages that the owner can establish. And it could be more than the liquidated damages. It could be less than the liquidated damages. Then there's provisions for extension of time. What entitles the contractor to an extension of time? Force majeure events, things outside the control of the contractor. So those are important to really have good provisions in there that everybody knows what limited events entitle the contractor to an extension of time. And suspension and termination are also important provisions. You want to be able to suspend the project in the event that something unforeseen comes up, that you have to stop the project because there's a design error that needs to be rectified. So you're able to, in those general conditions, put timeframes on suspension, because in a general AIA contract, the contractor would have, for example, 30 days. If there's a suspension lasts longer than 30 days, the contractor would have the option to terminate the contract. So you'd obviously, 30 days is not a long period of time in a construction project. So you'd want to modify that provision to provide the owner more leeway in the event that it has to suspend the project, and limiting the recourse in the event of such suspension, whether they're entitled to additional compensation for remobilizing and things like that. And then termination. Obviously, termination is a drastic remedy that nobody wants to impose upon a contractor. In some instances, it's absolutely necessary. But defining events of default that qualify for termination, and it can be, typically in the AIA, there's 5 or 6 items, and in the ones we modify, we put 15 to 16 items that would qualify for a default termination, and limiting the remedies on such a termination in the event that it's determined to be a wrongful termination, that it can be converted to a for convenience termination, to protect the interest of the district if it's ultimately determined that there wasn't a substantial basis for terminating the contract. Tip 6 would be establish in the contract documents a time frame by which the work is to be completed. Usually in the bidding documents, you're going to have a milestone schedule that's been created by the architect and the construction manager. It could be based on phasing or buildings, but that establishes the substantial completion date that's been agreed to by the parties and needs to be held by the contractor needs to meet those dates, or it's in breach, either subject to liquidated damages or actual damages if it fails to meet those. And it's important to keep informed of the status of schedule and try to deal with schedule slippages as soon as they appear. In some ways to do that your CM or your architect, would require that the recovery schedule from the contractor, give us a schedule by which you're going to recoup the lost days you did because you only had 5 people there instead of 20 people there. So that type of, what's your schedule for getting back on schedule or on time. Withhold payment in the event that they're not complying with the schedule. Supplement the workforce. And there's a provisions, a notice to cure or notice to correct under the general conditions, which in the event, depending on the time frame put in there, it could be 48 hours, it could be 3 days or 10 days. That if there's a default by the contractor, the owner can, upon that notice, trigger a time frame by which the contractor has to remedy that default. And by failing to do so, the owner can take over that work and then back charge the cost of the contractor for doing so, including its additional CM costs, additional architect costs. So that's a powerful remedy to get a contractor moving, and if not, it affords the owner an opportunity to keep the project on schedule and complete that work. Another item is to notify the surety. So in these cases, your contractor is going to have both payment and performance bonds. And it's the performance bond that really protects the owner, which is the sureties, guaranteeing performance of the contract by the contractor. And in the event that there's a potential for a default, you can notify the surety either by copying the surety on the notice, or more formally an intent to declare a contractor default, which is a significant event under a performance bond, which is the first step to trigger the surety's liability, and is a step that you need to do to keep the performance bond in play. And I'll tell you this from experience: sureties are not happy writing, just simply writing checks, unless the contractor abandons the project. You're typically getting pushback from the surety that, because they have a general agreement of indemnity with the contractor, And if the contractor says we have defenses to these claims, the surety will let them try to prove the defenses and defend the surety in an action. So it's not a magic bullet getting the surety involved, but it can be helpful because it can impact the contractor's ability to get surety bonds on additional projects. And so it's something in the owner's quiver that can be used in the right circumstances. Issuing a default and a termination notice, obviously a drastic remedy. It's not in anyone's best interest to terminate the contract, but in some instances it can't be helped. And and in that occasion, the remedies and your general conditions are, that you stop paying the contractor, and your damages are, credited against the remaining contract balance. There's no additional payment due to the contractor till the work's complete. And if the cost of completing the work is in excess of that contract balance, the contractor owes that money, or the contractor surety owes the owner that money. Tip number 7, back to insurance, because insurance is an important element of any construction project, because it essentially allocates risk. Who's at risk, and what's the remedy in the event of certain things. And it can be a personal injury, it could be a design error, design omission. So you want the right insurance established for the project as to coverages and limits. And typically we recommend insurance be vetted by the district's insurance professionals, insurance consultants, as to the CGL, the commercial general liability policy, the base policy, and the umbrella limits. You're seeing, it can be based upon the value of the contract and the value of the project. Those limits can increase, or you can have a set limit of $5 million CGL policy with a $10 million umbrella. A consideration is to have an owner's contractor's protective policy. So that can be inserted in the insurance requirements, where the contractor has to purchase that policy, and that policy protects the owner. It protects the owner in two ways: for its vicarious liability in the event that it gets sued for something the contractor did, as well as its own failure to supervise the contractor. The extent the claim is from an injured party is based upon the failure of the owner to supervise the contractors or supervise the project site. That would trigger the OCP policy, which is a standalone policy separate from the owner's own policy. So it provides another level of protection to the owner, and it's baked into the contract price that that the contractor bid on. Pollution liability policies, to the extent there's abatement with the project, asbestos, lead, whatever the hazardous materials is, you want those limits available or required, that type of policy required relative to that type of abatement activity, to prevent, in the event of a release, and potential personal injury or property damage associated with that release. And you're going to want to make the insurance requirements part of the bid documents. And how that typically works is, some architects or CMs will have an insurance rider that they'll include in the bidding documents. We put them generally in the Article 11 of the general conditions, which is a multi-page article identifying all the different required insurance for the project that the contractor and or its subcontractors have to provide to be awarded the project and to move on with the project. If there is a rider, I would just make sure that the rider is consistent with what's in the Article 11 general conditions, so you're not having two separate sets of insurance requirements. And then obviously you're going to require proof of the insurance, and we typically make it beyond the certificate of insurance, but also the endorsements, like the endorsement for additional insured, endorsement for cancellation of the notice on cancellation, endorsements for the waiver of subrogation. So not only the COI, but the actual endorsements be provided. And then you're going to have somebody within either the district or the CM to vet those and review those insurance requirements and monitor them, because multi-year projects, the insurance is going to lapse and have to be renewed, and you want to make sure that they have the same insurance throughout the project. And then establishing requirements for payment and performance bonds. Generally, the payment and performance bond is 100% of the contract value. It can be more. You can require them to have more than 100%, but generally it's 100%. And now what we see often is required riders that have certain provisions that just specifically requiring notice to the owner in the event of certain claim defaults. Also, for the warranty obligations, that making crystal clear that the surety is on the hook for the contractor's failure to honor its warranty obligations. And the warranty obligations, there's there's a general warranty that the work has to comply with the requirements of the contract documents, but there's also a callback or a comeback warranty, 1 or 2 years, depending on the districts, how they want to proceed in that fashion. But that requires within that time period, upon notice of defective work, that the contractor has to physically come back and repair that work. So that's a provision that you want the surety company to honor that provision. And so the riders, if it's in the contract, it's the surety's bound by the contract, but a belt and suspenders approach is to have a rider that's physically attached to the surety bonds that are submitted by the contractor. And then with regard to the bidding process, due to General Municipal Law 103 and the vagaries and uncertainties of the competitive bidding process, you're sometimes stuck with a contractor you don't want, unfortunately. And so there's certain avenues to identify. So what the owner is required to do is award it to the lowest responsive and responsible bidder. So those are 2 separate items and 2 separate requirements. So responsiveness speaks to the contractor's responsiveness to the bidding documents, the bidding requirements, what's in your bidding specifications as to far as experience on comparative capital projects, the number of years in business, the submission of financial statements, the submission of their contractor qualification statements. So so those are set forth in your instructions to bidders. So we've modified those to include a fairly comprehensive and robust requirement for bidders that allow the owner to and its consultants to understand if the contractor is capable of performing this project. And with regard, the thing about a responsiveness analysis is the owner or the district can hold the bidder strictly compliant to those bidding instructions or bidding requirements. If they fail to comply with it, whether it's a material non-compliance or a non-material non-compliance, the owner can reject the bid on a responsiveness basis without a hearing, without notice and an opportunity to be heard. So that provides an avenue to to protect the interests of the owner. The second prong is a responsibility. That essentially that the contractor is capable of satisfactorily performing the work within the specified time for the agreed upon price. And that's really, have they performed before on similar projects? Do they have the financial capabilities? Did they have enough money? Do they have a big enough line of credit to fund the project for a period of time in between payments? Are they self-performing 25% of the work or whatever the requirements are? Have they been convicted of a crime? Have they had multiple lawsuits? Have they had default terminations? There's a whole host of issues that speak to a contractor's responsibility. And it's up to the owner and its project team, its CM and its architect to to do some type of investigation and determine whether they meet that responsibility requirement. Again, based upon the contractor qualification statement, references, calling references, doing a litigation search, what we're generally asked to do, or sometimes asked to do, and see, have they been involved in lawsuits? Have they sued the owners for, has the owner sued them for delay, for defective construction? Or does the owner have has the owner had a prior project with this contractor that went poorly, where they didn't comply with the contract? There were delays, there were cost overruns, those type of things. And the responsibility can be a stain on the record of a contractor that's into public works, because they typically have to disclose that. So, it requires the owner to give them a notice and an opportunity to be heard. So they're going to send them a notice saying, your responsibilities in question due to the following things. We're going to give you an opportunity to present your side of the story at this responsibility hearing on such and such a date. And what it is, it's a rational basis standard. If they challenge it, they can challenge it in a non-responsibility determination in an Article 78 proceeding. It's the rational basis. It's not, the court doesn't second guess or substitute its judgment for that of the owner. It's just, is there a rational basis? Is there evidence that supports the determination of non-responsibility? Failure to complete another project, material false information on its contractor qualification statement, inability to fund the project, poor financials. So those types of things that are able to allow the owner to make sure that they do in fact get the lowest responsive and responsible bidder for their project. Tip number 9 is relative to change orders. Change orders, unfortunately, are inevitable in a capital project. They can result from unforeseen conditions, owner initiated. The owner decides, hey, we want to upgrade this tile to an enhanced VCT from a regular VCT, or it can be an error and omission. And so the general conditions handle and the front end specifications that contract modification process. And they should establish the format for a change order request or a change order proposal, substantiation requirements, and then applicable markups by prime contractors and their lower tier contractors. A lot of the times we see 15% overhead and profit maximum, and then that's divided. That's depending on whether the contractor self-performs or if it's a subcontractor work, it's divided between between the contractor and the subcontractor. But there's also provisions for, what's included in the markup. Is supervision included in the markup, or do they get to add supervision on top of a markup, or estimating, or material handling? So we like to put in as much stuff in the markup, to limit that cost to the owner. And sometimes you can tier the markups depending on, the higher the change order, the lesser the markup. The lower the change order, obviously, the higher the markup. And then whether on a deduct change order, whether they're refunding overhead and profit that they had in their bid. The base AIA doesn't provide for that, but it can be modified to in the event that you de-scope certain work, that the overhead and profit that they didn't earn on that is returned to the owner. And then, I think it's important to keep your architect and your CM, on task with regard to the change order review and vetting the cost. Your construction manager is obviously a professional in the construction industry, and it has a sense of, are these costs, within line what you would expect. You're going to pay more on a change order because you're not, you don't have any competition. And then whether it truly is a change. whether it's reasonably inferable from the design documents that they had to provide, sills on windows or something that they're looking for a change order. So you really want them to look at it and make sure that, it's a legitimate cost that they're entitled to additional compensation for. Then the final tip, tip number 10. So, deal with problems when they arise and include, to the extent you think appropriate, your legal counsel early on in the process with the goal of mitigating or the risks of mistake and avoiding escalation of a dispute. Especially if your counsel's, drafted the general conditions, they have a good understanding of the general conditions and more so typically than the CM and the architect on what provisions may be implicated and what limitations there may be on contractor issues that can be handled before the dispute gets to the claims process or unfortunately the litigation process. And there's notice provisions in your general conditions, notices by the owner, notices to correct that can be issued as we talked about earlier. Delay notice is required by the contractor, that they have 3 days notice to notify the owner of a delay. And if they don't notify the owner of delay, then they waive that claim for either additional costs or additional time. Obviously an owner doesn't want surprises and doesn't want at the end of the project to be presented with a change order request for extended general conditions and other delay costs that the contractor claims resulted from your owner delays or the owner's consultant's delays in responding to their RFIs or approving their submittals. You want to establish early on that that they have to meet these notice provisions so you can ameliorate or mitigate the issues that they've identified early on in the project instead of waiting till the end. Notices to the surety. Your surety bond has particular notices that you have to abide by to keep that bond in play. Liquidated damages notices. It doesn't make sense during the course of the project to say you've missed a substantial completion date. The district's now exercising its rights to impose liquidated damages and give them notice of that. Withholding payment, there's, under Article 9 of the general conditions, the architect, the CM, and as revised, the owner has the ability to withhold payment based upon, or withhold certification of payment based upon, failure to correct defective work, failure to timely complete the work. But there's requirements that you got to give the contractor notice of that withholding. Lien discharge notices. The contracts generally require the contractor to bond off liens. If a public improvement lien will attach to the contract balance, it doesn't attach to the district's property. They can't force the district to sell the property. It's really limited to the balance, the contract balance when that lien was filed. But you don't want to have to deal with the lien. You have an obligation that if the contractor hasn't paid its contractors, and even if that is a legitimate dispute, if there's a lien filed, the contractor has to bond off that lien. And then termination notices. It's important to stress that your termination notice has to exactly comply with the requirements of the contract documents. The courts have held that if you don't strictly comply with the requirements of the termination provisions of the contract with regard to notice, opportunity to cure, whether the architect has to certify that there's a substantial basis for terminating the contract. If you don't comply with those provisions, there's an argument given to the contractor that that determination was wrongful. So you want to strictly comply with those notices, and hopefully you never have to issue that notice of termination. But if you do, you just need to strictly comply with that notice, and it may make sense to get your legal counsel involved at that point to make sure that there's no missteps to avoid any potential liability on behalf of the district. So those are the 10 tips, and there's probably 100 more that we could talk about and have days of a webinar on issues that can arise during a capital project. But hiring a good architect and a good CM are benefits to the district and will benefit you as you prosecute your ongoing capital projects and your new projects. So thank you for your time. I appreciate it, and happy holidays to all.